Let's talk about the criminal charge of intimidating a witness. So intimidating a witness is when you scare or try to influence the witness into not testifying or into changing their story. Now, the way you intimidate the witness can be overt or obvious in ways such as physical violence, threats of physical violence or other threats, but it can also be more subtle by showing up at someone's house, for instance, having a group of people stare down the witness. It can also happen inside of court or outside of court, depending on the situation. It can also be by giving the person money or other things of value in order to change their testimony. In other words, you're bribing the witness not to testify or to change their story. Now, the most common way we see this charge come up in district court cases is when somebody takes the phone away from somebody else who's trying to call the police. Most commonly, these are in domestic violence cases. So let's say that you're charged with domestic violence. In Massachusetts, that's known as assault and battery on a family or household member. And not only are they saying that you, say, slapped this person, but while they were trying to call the police for help, call 911, you took the phone away from them so they couldn't reach out for help. Now you're being charged with assault and battery on a family household member, as well as intimidation of a witness. And it's very important, the intimidation of a witness, as odd as this sounds. So the physical striking of the person is a misdemeanor. The taking the phone away from the person is a felony. So it's an even more harsh and more important charge that you're facing rather than actually physically harming the other person. It seems a little odd to me, but that's the way the law is. Here's an example of how we got around that in one of the cases. So it was an assault and battery on a family household member and an intimidation of a witness charge. Two charges on the same complaint. So the way we argued was that the phone was taken away. Yes, our client did take the phone away from the alleged victim, but it wasn't during a time when the alleged victim was trying to call the police. She wasn't reaching out to 911. It was just on the kitchen counter, and he took it on his way out. So we were able to argue that the alleged victim, wasn't trying to use the phone to reach out for help. He was just retrieving his own property. In that way, we got the intimidation of a witness charge dropped, so the felony was taken off the table, and then we had to deal with the assault and battery on a family or household member on its own, which is still a serious charge, of course, but it's a misdemeanor and not a felony. So what you want to do is, if you're charged with intimidation of a witness or anything, call us right away. The most important thing is that we get on board as soon as possible, and for whatever you do, please do not speak to the police. Do not make any statements to the police. A lot of times people say, I'll just explain myself and the case will go away. That's usually not what happens. You can only get yourself in trouble by making statements that can be used against you. You have the right to remain silent. You should definitely do that. And if you're worried about fees, our fees are based on a sliding scale, which is tied to your income. And what that means is that the less you earn, the less you have to pay for our services. So give us a call today, and we'll be able to discuss your case and see how we can help you without costing you a fortune.